Hi guys, so we are on chapter 14, which is focused on diplomatic law and agents of international intercourse. Diplomatic law is an area of international law that governs diplomatic missions and primarily deals with the question of diplomatic immunities. So, who are these diplomatic agents? Well, diplomatic agents and the establishment of a category of individuals as diplomatic agents goes back all the way to the Westphalian Treaty of 1648 and is a Westphalian legacy which establishes the notion of permanent diplomatic missions in Europe, which at the time were governed under customary international law. Then this customary international law is codified in the 19th and 20th centuries through these mechanisms that I have enlisted on the slide. It begins with the Congress of Vienna in 1815, and it evolves through the Congress of uh, Aix-la-Chapelle in 1818, which systematizes mostly diplomatic etiquette among major European powers like Austria, Prussia, France, Great Britain, and so forth. Then the next phase of evolution occurs through the Convention regarding diplomatic officers, which convenes in Havana in 1928. But really, the most two important modern mechanisms for governing diplomatic law are number one, the Vienna Convention on Diplomatic Relations, the so called VCDR of 1961, and the Vienna Convention on Consular Relations of 1963. But most of the stuff that we're going to be covering in this chapter is derived from the VCDR of 1961. A key notion in diplomatic law is the notion of persona grata and persona non grata. In diplomatic law, as a matter of statecraft, before a diplomatic agent is appointed, the sending state should verify the acceptability of the agent, which, if accepted, then the person is called a persona grata. And if the receiving state refuses the nominee, she or he is considered persona persona non grata. Please remember that the host nation may at any time and for any reason declare a particular member of the diplomatic staff uh, persona non grata. This is pretty common practice actually, and it happens quite frequently. And if that happens, the sending state has the responsibility to withdraw this person within a reasonable amount of time. They're normally given, from a few days to maybe a few weeks for the persona non grata to be recalled. Otherwise, that person or people will lose their diplomatic immunity. Declaring persona non grata is probably one of the most convenient and common ways for the host countries to expel diplomats who are suspected of espionage, serious criminal activity such as drug trafficking, sex trafficking, and so forth. And sometimes declaring a person persona non grata is used for symbolic reasons, which indicates the displeasure of the host country. And like I said, this was pretty common practice in the relationship between the United States and the USSR during the Cold War era. Uh, the next topic in diplomatic law is the so called inviolability of legation premises, which according to the VCDR, and this one goes even before the Vienna Convention on Diplomatic Relations. And according to this principle, the premises of diplomatic missions, the so-called legation premises, are inviolate. In other words, they must not be entered by the host country without the express permission of head of the mission. The host country has the responsibility also to protect the mission from intrusion or damage. The host country shall not search the premises or seize its documents or property, because these are considered privileged communication, and they also enjoy complete immunity from intrusion, seizure, search, and so forth. And the same immunities and privileges also apply to the private residence of the diplomats that are properly registered. Article 27 of the VCDR deals with the question of freedom of communication, according to which the host country must permit and protect free communication between the diplomats of the mission and their home country. The diplomatic bag must never be opened, even on suspicion of abuse, because, like I said before, these enjoy diplomatic immunity status, and a diplomatic courier must never be arrested or detained. Diplomats are also immune from civil or criminal prosecution, and I have enlisted those immunities on the slide. I'm not going to read all of them, but to touch upon them, diplomats, according to, again, the VCDR of 1961, must not be liable to any form of harassment, arrest, or detention. They enjoy immunity from civil and criminal prosecution, and only the sending state may waive diplomatic immunity. Diplomats are also exempt from paying taxes or customs duties and those types of limitations that ordinary citizens face. The only exception is the so-called functional necessity theory that covers actions that are not part of diplomatic community, and these include, for example, professional activity outside diplomats' official functions. And on the question of abuse of diplomatic immunities, the VCDR mentions that without prejudice to their privileges and immunities, it is a duty of all persons enjoying such privileges and immunities to respect the laws and regulations of the receiving state. The important note here is that the head of the mission, the staff of the mission, and their families do not require the nationality of the receiving state. So those nationality and naturalization laws that we covered in the previous chapters, they do not apply to the diplomatic staff and their families. This is more of an expansion on the notion of diplomatic immunities, and as you can see on the slide, diplomatic agents enjoy the highest degree of privileges and immunities. They enjoy complete personal inviolability. They cannot be handcuffed, for example, except in extraordinary circumstances. They cannot be arrested, detained. Their property, vehicles, or their residences cannot be entered or searched, and they enjoy complete immunity from the criminal jurisdiction of the host country's courts and cannot be prosecuted, no matter how serious the offense, unless their immunity is waived by the sending state. And remember that the immunity can only be waived by the sending state and not by the host country. An important note on U.S. law is that the family members of diplomatic agents enjoy none of those privileges if they are nationals of the United States. So if they're nationals of the United States, they could be subjected to U.S. Court system. Also, diplomats enjoy immunity from civil suit, except in four very limited circumstances, which are in connection with real property transactions not conducted on behalf of the mission. So this is basically a private transaction, or in connection with any role they may play as executor for or heir to an estate being distributed in the host country. C, in connection with the performance of professional or commercial activities outside the scope of their official duties. Or D, in respect to counterclaims on the same subject matter when they have been the initiating party in a suit. So as you can see, unless these diplomats are engaged in transactions that fall outside the purview of their diplomatic functions, they are completely immune from any civil lawsuit. Also, diplomats enjoy complete immunity from the obligation to provide evidence as witness and cannot be required to testify, even, for example, if they've been the victim of a crime. Now, there are a bunch of restraints on diplomatic agents that kind of complement those diplomatic privileges and immunities. And these restrictions include abstention from interference in the internal affairs of the receiving state, affiliation with political parties, electioneering and dissemination of propaganda, espionage, smuggling, child custody law violations, and murder. Now, there are three main mechanisms for dismissal of diplomatic agents. It could be done either through the waiver of immunity, which is done by the sending state, or through voluntary yielding of immunity, for example, through resignation or via defection and so forth, or if the diplomat or the diplomatic agent is declared a persona non grata. Next, you have the immunity of the diplomatic mission, or as they're called in international law, legation quarters. Legation quarters are also inviolable except with the permission of the head of the mission. But remember that they don't enjoy extraterritorial status. In other words, diplomatic missions and legation quarters are not sovereign territory of the represented or the sending state. And these legation quarters remain under the jurisdiction of the host country, while obviously enjoying those special privileges. And this, status presents an interesting case when it comes to the question of asylum seeking, because asylum seeking in legation quarters falls at the intersection of international law and international politics, and normally law and politics conflict with one another on this issue. But the general rule is that since embassies do not have extraterritorial status, the question of granting asylum is, like I said, at the intersection of law and politics. But keep in mind that because of the inviolability of legation premises, once someone enters them, essentially local authorities cannot enter to obtain or arrest the asylum seeker. A case in point is Julian Assange and him seeking refuge at the Ecuadorian embassy in London. So on the question of diplomatic issues, there are a couple of examples and points to bear in mind. One is the intervention in internal affairs versus human rights concerns, and this is something that crops up in when someone enters those legation premises and seeks asylum. The International Court of Justice opinion, and again, this is an advisory opinion, is that a decision by a mission to grant asylum involves a derogation from the sovereignty of the receiving state, because obviously the legation premises are still part of the sovereign territory of the host country. There are two well-known examples of these types of derogation from the sovereignty having happened. One was the Peruvian embassy in Havana, when about 10,000 Cubans sought asylum by taking refuge on the grounds of the Peruvian embassy in Havana, and eventually Fidel Castro decided to allow them to go, which is referred to as the Mariel Exodus and boat lift of 1980. Another well-known example is the Canadian embassy helping out the exfiltration of American diplomats following the storming and the takeover of the American embassy in Tehran after the Iranian Revolution of 1979. Next slide is on diplomatic ranks, and these ranks are in descending order of seniority. So the most senior or top diplomatic agent is referred to as ambassador extraordinary and plenipotentiary, who is the head of the mission representing the head of the state with plenipotentiary powers. In the case of the Vatican, the Holy See is represented by the so-called papal nuncio, sometimes referred to as the papal legate, who's essentially the papal ambassador. In Commonwealth countries, this person is referred to as High Commissioner, who represents the government but not the state. Then the next rank is minister, sometimes referred to as envoy extraordinary, minister of plenipotentiary, or in the case of the Vatican, papal internuncio, who is the head of the mission but is not a representative of the head of state. Next rank is minister residence. That is the lowest rank of full head of mission above charge d'affaires. And finally, you have charge d'affaires, who is someone that's temporarily in charge of the affairs of the diplomatic mission when there is no ambassador plenipotentiary available or in presence. Also, you have the dean or the doyen of the diplomatic corps, who is the most senior diplomatic representative of the diplomatic corps, serving the longest time in the United States. And this is, a title whose functions are largely ceremonial, and the most well-known in the United States of the doyen of the diplomatic corps is Anatoly Dobrynin, who was the Soviet ambassador to the United States during the Cold War from 1962 to 1986 for about 24 years. And finally, you have the 6 functions of diplomatic agents, again, according to the Vienna Convention on Diplomatic Relations of 1961. These functions include negotiating with the host country, representing the sending state, gathering information, and protecting of the nationals of the sending state, also some public relations and promotion of friendly ties functions, and finally administrative functions that diplomatic agents discharge.